law do we have in here? Right?
Yes, I can.
Yeah, yeah, we can
Okay.
see it.
All right. This is the new pleading we've got to get filed. We're doing the exact same thing as we did before with some additional language and some lesser language, but we're basically refiling a new challenge to the amended complaint, Jane.
Yes.
Okay. So we're going to assume for the moment that the court denied the other one because they changed the complaint. So now we're going to file a new one challenging that complaint for exactly the same reasons, but challenging it nonetheless. Okay.
Is it Deborah, Debra, at Rule of Law?
Deborah.
Okay.
Yeah.
Okay. Oh, yeah, okay, I got it right here.
All right. Now, notice that we changed the title of it, still challenging subject matter jurisdiction in the quash and set aside City of Irving's amended complaint. Okay. So the very first part begins basically the same all the way down to here. Okay. Well, we're basically making the same allegation that the amended complaint didn't change anything other than just taking out language that shouldn't have been there in the first place. So, no offense alleged in the complaint. The prosecution has alleged that the criminal complaint has been amended so as to correct its insufficiencies and deficiencies in alleging an offense against the law of this state. This assertion is an attempt to mislead and perpetrate fraud upon this court and the due process rights of respondent. As in the previous complaint, the amended complaint still charges no offense. It simply parrots the same vague, ambiguous, and overbroad language of the ordinance virtually verbatim, while providing absolutely no specific facts and details relating to the elements thereof, which is a mandatory part of the allegation. Albeit, while the alleged complaint now contains only a single section of the ordinance that was allegedly violated instead of every possible section of the ordinance, it still charges no offense. While the amended complaint removed the language related to the other provisions of the ordinance, the one that remains still failed to provide any kind of factual specificity for the charge. The complaint, in pertinent part, now reads, did intentionally feed an animal or made food available for animal consumption in a manner that creates a danger to public health or safety in violation of Section 6-80E City of Irving Code of Criminal and Civil Ordinances. Furthermore, the alleged criminal complaint still alleges an offense against Section 680E City of Irving Code in general, rather than to any specific section and offense therein, such as Section 6-80E1, for example, which is the only section the language of the alleged complaint now parrots. Therefore, respondent is once again forced to address the entirety of Code Section 680E in order to preserve the objection for appeal. Lastly, there are still no specific facts alleging what danger respondent actually created, what specific persons within the public allegedly suffered any actual harm relating to such danger, or how the entirely speculative danger allegedly affected the public health or safety of those persons or the public in general. In short, the state, and we're not going to say that, in short.
And also, sorry to interrupt you, but are you going to address the fact that she's already said that?
Jane, we just started. What do you want me to address that I haven't read yet?
Well, you didn't let me finish yet. The part, I mean, how she said what you just got through reading, she's still going to come back and say what she said. So are you going to say, well, just because she, how she.
Can I finish reading it before you start asking me these questions?
Okay.
In short, the city attorney has neither alleged nor can prove that any specific danger was ever created or existed, or that respondents' actions actually affected the public health and safety in any way. Nor can the state produce any alleged victims that can demonstrate that they were subjected to any danger to their health or safety, or even what specific danger that would be, because it just didn't happen. The entire allegation is 100% speculative and subjective without the assertion of a single demonstrable fact, and thus fails to allege any actual offense against the laws of this state or the City of Irving Code. Demonstrable fact or circumstance. All right. And then we left in the same challenge to Code 680 being constitutionally vague, ambiguous, and overbroad. And then we addressed the city attorney's improper reading and interpretation of CCP Article 45A 101. The city attorney alleges that because the complaint allegedly contains all the general requirements for a criminal complaint as codified by Code of Criminal Procedure Article 45A.101, that the complaint is therefore valid as written. However, the city attorney's arguments demonstrate a fundamental misunderstanding of what is required by Article 45A.101A4 to properly and legally allege an offense. In order to allege an offense against the laws of this state, the complaint must assert all of the necessary fact elements that are required to be asserted and proven at trial with particular specificity, which the amended complaint still fails to do. And Article 45A.101A4 makes no mention of being a requirement. Let's just change this to complaint still fails to do, regardless of the fact that Article 45A.101A4 makes no mention of such a requirement. The fact that the language of CCP 45A.101 does not expressly require such details and specificity does not make it any less of a legal requirement. For example, nothing in Code of Criminal Procedure Article 45A.101 requires that both the posted speed limit and the alleged speed of the offending motor vehicle be stated in a criminal complaint used to charge and prosecute an alleged speeding offense. But the complaint is still considered legally invalid and insufficient or deficient to charge an offense where it fails to allege either of those factual details, as both facts comprise two of the several required fact elements needed to charge and prosecute an alleged speeding offense. Therefore, just because Article 45A.101 makes no specific mention of such fact element requirements in alleging an offense, it does not invalidate the inclusion of such factual details as actually being a requirement to do so. In this matter, the amended complaint still fails to allege and identify any specific danger allegedly created by respondent, nor does it identify any specific persons whose public health and safety were harmed or threatened by respondent's actions, nor does it state any facts pertinent to how those actions in and of themselves are a violation of any law or ordinance. Thus, the complaint, amended or otherwise, still fails to allege a valid offense against the laws of this state. We left in the feeding animals outdoors as not criminal conduct. The city attorney has also attempted to mislead this court by arguing that respondent only provided hypothetical examples of how the ordinance in this matter could be misused and abused by the city of Irving and the city attorney's office. However, the fact that respondent is being maliciously prosecuted under the related ordinance precisely because of such misuse and abuse is not hypothetical, it is demonstrable fact. So while respondent did provide other hypothetical examples of how this ordinance can be very easily misused and abused, that does not negate the fact that respondent's case is a factual example of that misuse and abuse. As was stated in respondent's original motion, the complaint appears to be, and that's where the same stuff again from the other motion.
Excuse me. Somebody can't see your video's not on or something like that. So I'm just reading the chat messages. Just letting you know.
I'm sorry, you're all right. I thought y'all could see the screen, so I didn't know they needed to see my face to see the screen.
Okay.
Could they not see the screen?
No, they couldn't see the screen. One guy can't see the whatchamacallit. Can't see.
Well, then why would any of you say you could see the screen? If one of you can see it, all of you can see it.
I can see it now, but somebody
No, we could.
Yeah.
I think it was on his end. We just didn't realize you didn't know that your video was off, which you
No, I
usually
knew
have
it was
on.
off. I just didn't see a reason to have it on at the moment. All I'm doing is reading.
Oh, okay.
But either way, if y'all like my pretty face that much, here it is. All right. Failure to provide proper, sufficient, and timely notice. Respondent, as was previously argued in respondent's original motion challenging jurisdiction and to quash or set aside the complaint, has a due process right to legally proper, sufficient, and timely notice in accordance with law. And the complaint before the court failed miserably in providing that notice and should be quashed or set aside and the cause dismissed on those grounds alone. The alleged complaint still fails to provide sufficient specificity in alleging an offense against the laws of this state. Shortening the same parroted language of the ordinance from 3 to 1 from 3 clauses to 1 shortening the same parroted language of the ordinance from 3 alleged clause violations to 1 within the complaint, while still failing to allege any specific and necessary factual details of an offense, still charges no offense. Subsequently, failing to properly and sufficiently allege an offense while continuing to prosecute respondent for a non-crime that was never alleged in any such complaint is still a failure to provide proper, sufficient, and timely notice to respondent, which is a violation of respondent's right of due process. This non-specificity as to what danger and to whom exactly respondent is allegedly being charged with creating deprives respondent of their right to proper, sufficient, and timely notice of the charges being made or how to defend against them. Once again, the amended complaint remains utterly devoid of any factual details, consisting of nothing more than a parroting of the text of the ordinance section without the inclusion of any specific factual context and details in support of the required elements of any alleged offenses therein. And this was all from the prior motion as well. The city attorney further attempts to mislead and perpetrate fraud upon the court and the due process rights of respondent by arguing that there is some alleged home rule city law that authorizes municipalities to enact binding public law. The city attorney then very mistakenly cites the Texas Constitution, Article 11, Section 5 as being the authority for such legislation. Respondent, and a chapter, what was the chapter of the government code she used? Jane, look through her, I've got a copy of it up, but I'm reading.
Chapter 9.
Chapter 9 of the government code?
Yeah, I'm trying to, hang on, I gotta find it. But it was chapter 9.
Well, if you can't find it and you haven't made sure of that, then I'm not going to write chapter 9.
Well, hang on.
Okay. Local government code, section 9.0001.
Yeah, that's it.
Hey.
He's still up there?
I'm gonna argue in the trial about the fact that people throw their trash out and it stays out overnight, and that doesn't attract any.
No, you're not.
Why not?
Because that's not relevant to your case.
The whole master bedroom painted, trimmed, everything except
I saw the pictures.
looks much better.
Okay. We don't really need to know how the master bedroom looks, so we'll mute them for a moment. Okay. All right, let me get the local government code up here for a minute so I can get my link to that. Oh, come on.
The wild animals don't know the front or the back of my house what the difference is and why why they wouldn't go dig in the trash versus my front porch. You know, I don't know why it's not relevant.
Municipalities. All right. Great. All right. The city attorney then very mistakenly cites the text of the Constitution, Article 11, Section 5, and Local Government Code, Section 9.001, as being the authority for municipalities to create binding public law in the form of ordinances. What the hell won't my fingers put these damn things in the order and type them in? Under the cover and authority of their municipal charter.
Are you going to say something like what it says and how she's misinterpreting it?
Jane, can I finish what I'm doing again?
Yes.
Well, thank you. Under the cover and authority of their municipal home rule charter. However, neither nor any such language or authorization. Any such language or authorization. As directly addressed. Look, you stupid thing. Later in this pleading, but suffice it to say, it provides for no such authority. In fact, Texas Constitution, Article 11, Section 5 expressly forbids any such authority ever being delegated to, usurped, or used by any municipal political subdivision. In short, the city attorney is lying to this court's very face. Okay. Furthermore, the government code also contains no such language or authorization. The adoption. Oh, man, fingers. Amendment of municipal charter. All right. Now, real quick, if we search section 9.001 and we locate the word ordinance,
It's not in there.
yes, it is. It's in there multiple times. Okay. However, what is not associated with it, and it actually appears in here 7 times, 5 of which are in section 9.002 alone, dealing with the selection of charter commission. The other 2 are in 9.004 dealing with charter amendment. Okay.
What I'm saying is ordinance is not in that section that she referenced, 9001.
Doesn't matter what she referenced, Jane. Everything she said was fucking wrong.
I know.
Government Code 9.004. See, there were the other ones. And 9002. Two. Local Government Code, sections 9.002 and 9.004. Charter connection. containing 5, 7. All right. Local Government Code sections 9.002 and 9.004 are the only two sections containing the term ordinance, with section 9.002 governing the selection of charter commission, containing 5 of the 7 references to the term ordinance that is found in the entirety of Local Government Code Chapter 9. Okay. Local Government Code section 9.004 to charter amendments. Neither section or any other section chapter is there any language conveying to a municipality of any kind, including a home rule municipality, is there any language conveying to a municipality of any kind, including a home rule municipality, the authority to create ordinances are to be applied and enforced on the general public as any sort of binding public law. Even if such language existed, which it does not, it would be unconstitutional on its face, as it would constitute would be legislation that attempts to invalidate and void specific sections of the Constitution. State of Texas Constitution. So specifically, it would be an attempt to render Article 3 so finally this is from the top of page 19, right? Article 3 section 1. Yes, to nullify any Texas Constitution a statute or enactment. To do so requires not only legislative a resolution, legislature also the voting consensus of the people of Texas, which has never been given for such changes. Only a resolution. Being passed in the approval of both houses. To do so requires not only a resolution to be passed with the approval of both houses of the legislature, but also the voting consensus of the people of Texas, which has never been given for such changes. In short, the city attorney is once again perpetrating fraud upon this court and lying to this court's very face. All right. Does that read correctly to everybody? Even if such language existed, which it does not. Well, actually, let's start at the top of this again. City attorney further attempts to mislead and perpetrate fraud upon the court and the due process rights of respondent by arguing that there is some alleged home rule city law that authorizes municipalities to enact binding public law in the form of ordinances. The city attorney then very mistakenly cites the Texas Constitution, Article 11, excuse me, Section 5 and Local Government Code 9.001 as being the authority for municipalities to create binding public law in the form of ordinances under the cover and authority of their municipal home rule charter. However, neither Texas Constitution, Article 11, Section 5, nor Local Government Code, Section 9, nor any part of Chapter 9 please. There we go. Part Chapter 9 contains any such language or authorization. Or could it? Respondent has directly addressed Texas Constitution, Article 11, Section 5 later in this pleading, but suffice it to say it provides for no such authority. In fact, Texas Constitution, Article 11, Section 5 expressly forbids any such authority ever being delegated to, usurped, or used by any municipal political subdivision. Furthermore, Local Government Code Section 9.001 also contains no such language or authorization, as it deals only with the adoption or amendment of a home rule charter and nothing more. Local Government Code Sections 9.002 and 9.004 are the only two sections containing the term ordinance within, with Section 9.002 governing the selection of charter commission, containing 5 of the 7 references to the term ordinance that is found in the entirety of the Local Government Code. And Chapter 9 of the Local Government Code. Five of 7 references to the term ordinance that is found in the entirety of the Local Government Code. Local Government Code Section 9.004 relating to charter amendments contains the other 2 uses of the term ordinance. Only to the elections. To the ordering of elections. Nowhere within any section of Chapter 9 is there an authorization to create ordinances. That are enforceable on the general public or private property. All right. Nowhere within any section of Chapter 9 is there an authorization to create ordinances that are enforceable upon the general public or private property and persons as if it were the same as binding public law enacted by the legislature. Or the equivalent. All right. In neither section nor any other section of Chapter 9 is there any language conveying to a municipality of any kind, including a home rule municipality, the authority to create ordinances that are to be applied and enforced upon the general public as any sort of binding public law. Even if such language existed, which it does not, it would be unconstitutional on its face, as it would be legislation that attempts to invalidate and void specific sections of the Texas Constitution. Most specifically, it would be an attempt to render Article 3, Sections 1 and 29 through 39 as being superfluous and of no effect. However, the legislature has no authority to nullify any provision of the Texas Constitution by means of statutory enactment. To do so requires not only a resolution to be passed with the approval of both houses of the legislature, but also the voting consensus of the people of Texas, which has never been given for such changes. In short, the city attorney is once again perpetrating fraud upon this court and lying to this court's very face. As respondent argued previously, the legislature cannot nullify entire provisions of the state of Texas Constitution by statutory fiat. And any such enactment, let's just fix this here. By legislative or statutory fiat, and any such enactment would automatically be null and void on its face. If the city attorney was actually correct, then that means that virtually everything within Texas Constitution Article 3 dealing with the delegation of lawmaking authority to the legislature alone is now superfluous and of no effect. Yes. Which, stated another way, would mean that it has all been declared null and void by legislative enactment rather than by constitutional amendment and a vote of the people of Texas. In short, the city attorney should be disbarred for even suggesting such a thing as possible, much less that it has already been done and is perfectly acceptable. Therefore, respondent must reiterate what appears to be blatantly obvious to everyone but the Irving City Council. That's not how you spell council. What the hell are you saying it is? The city attorney and this court. It is constitutionally impossible for a city council to legitimately usurp or receive by legislative redelegation the constitutional power to enact law, as that power is exclusively delegated to the Texas legislature pursuant Article 3, Section 1, Texas Constitution, regardless of whether or not that redelegation was attempted by a statutory procedural rule or any other means. And there we go back into everything we already had in the initial motion. And here's what we talk about where Article 3, Section 1 and Section 5A says that they can't do what they're trying to do. All right, malicious prosecution. Actually, I need where. That's right. Okay. All right. The city attorney disingenuously argues that respondent's initial motion was making a civil claim for malicious prosecution during the related criminal proceeding. This is yet another example of the prosecution's efforts to mischaracterize the contents of respondent's pleading so as to misdirect and mislead the court. Respondent is well aware of the facts and circumstances needed to assert and prove a malicious prosecution claim, and that the claim is not yet ripe for filing such a claim. A tort claim. That's the issue. Is not yet right for filing such a tort. Which is why those facts were why many necessary facts were not alleged in the pleading, and respondent was not making a civil claim for malicious prosecution. And why respondent was not making a civil claim for malicious prosecution during a criminal proceeding. However, what respondent was doing was putting the prosecution on notice that respondent is fully aware of where this act of malicious prosecution would eventually lead by laying out and documenting all the relevant facts and circumstances currently supporting such a claim for use in a future action. Respondent is quite confident that the very fact that the city attorney is knowingly and willfully pursuing prosecution for a non-existent offense and without any factual evidence supporting any offense at all will be more than ample ground to lay the foundation for an act of malicious prosecution in a civil tort.
Good.
The amended criminal complaint still fails to allege with any level of legal specificity any violation of a law of this state, which an ordinance absolutely is not and cannot be, and which is a requirement for any such complaint pursuant Code of Criminal Procedure Article 45A.101, regardless of that section's unconstitutional attempt to validate the unlawful prosecution of an ordinance against private persons or property.
Are you going to mention anything about the judge, about how denying the motion or not?
Again, respondent further, lastly, should the court deny this motion, respondent hereby moves the court to provide a written finding of facts and conclusions of law supporting such denial for the record and the purpose of appeal and other potential actions. Okay. Now, did I answer the question you thought you needed to ask so early on? Hang on just a second.
Yes, you did. Yes.
Okay. See, if you just be patient, let me finish. We might have all this worked out ahead of time.
Okay.
Can I ask a question?
Sure.
The findings of facts and conclusions of law, will the judge more than likely just overlook them?
No, they'll more than likely refuse to do it.
And they're more than likely just deny this one too.
Well, when you say refuse to do it, would they give a written statement why?
Well, that would be at least answering it, and they're not going to do that. See, the reason they wouldn't do it is because they have no way to do it. Not without proving that they don't know what the fuck they're doing. Because they have no legal argument that can overcome what we've argued in this. The complaint doesn't allege anything.
So this all bases in the them refusing to obey the Constitution.
And chapter 9. And...
Wait, say that again?
Well, you bring everything back to the Constitution. The rights.
Well, not just the Constitution, but the legal requirements for what a complaint has to have.
Okay.
See, they're arguing that it has everything. We're arguing that their attempt to use 45A.101 to say that it does have everything is invalid. And that it's a violation of our right of due process to not provide the specific fact elements in the complaint that aren't there. They just flat out aren't fucking there.
Hey, Eddie.
Hang on, let me finish my train of thought on this. And as far as the constitutional side of it goes, they're attempting to use ordinances in place of binding public law, and that is a violation of the Texas Constitution. because nowhere does it authorize municipalities or counties to create ordinances that authorize them to act as if they're the legislature. Now, they can make an ordinance for any internal thing they want. They can use ordinances to govern their city as far as controlling their employees, certain types of businesses operating within their territorial limits over which the legislature gives them regulatory authority, and over its contractors who must abide by the rules they have in their policies whenever they're doing business with them. But the rest of us can only be made to comply voluntarily. And if we choose not to comply, there ain't a damn thing in the world they can do about it. Because for them to be able to do so would make the ordinance an actual law that we all had to comply with, and thus that would be a violation of the Texas Constitution on its face. Does that answer your question?
Yep. So what about, I sent you an email about the judicial conduct complaint. Is that something that that they'll address since it was the judge's decision on the case? And so
why did you file a judicial conduct complaint?
I did not. I'm asking
Okay,
you.
we're not filing one till the judge gives us sound grounds for doing so.
Okay.
You don't file a complaint against the judge for rendering a ruling. You file a complaint against the judge for rendering a ruling that's in violation of rights or law. You got it?
Mm-hmm.
Right now, they didn't tell us why they denied your original motion. So I am operating on the presumption they denied it because the city attorney amended the complaint. And the judge was operating under the incorrect presumption that the complaint was the only issue to be addressed here. And it isn't.
But she made the points, you know, she addressed most all the points that we had in there, but incorrectly did so. So
no,
you don't,
the city attorney did. The judge did.
That's what I'm saying. She did.
Well, a judicial conduct complaint doesn't have a damn thing to do with the city attorney.
I know. What I'm saying is she addressed those points. Therefore, he actually is supposed to have read the motion, her motion, and
it doesn't matter that the city attorney addressed those points. It matters that the judge carefully read and analyzed the argument to see if it actually was consistent with the law. And it isn't.
No, he didn't. Yeah.
Now that's something I had a question about because on my pretrial hearing on Friday, I don't know if you got to see the video.
No, I haven't.
Okay. Well, those particular things, I never got anything in writing, number one, as far as their rebuttals against our motion that we filed, of course. And then, you know, I told them, you don't have subject matter jurisdiction, blah, 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 explaining what was in my motion as to why. And that, of course, exactly as you said, the assistant district attorney said, well, the complaint is sufficient on its face because you have all these elements at the time of night when the headlamp wasn't working and blah, blah, blah. And I'm like, no, you're just restating what it says. You don't have all the fact elements. So therefore, there was never jurisdiction to begin with. Oh, yes, there was.
But you never got a ruling on it. She never got a
I
ruling.
never got a ruling on this. So I don't know what.
Did you object?
Yeah.
She started arguing on the merits.
Yeah. See, I'm having, and I need to learn all of this, and I get it. I get I'm going to make my damn mistakes, but still, I should have had a ruling, and I didn't get one. And I said, look, I want this in writing. I want your rebuttal in writing. And I want a copy. So that way it gives me time to be able to respond. Oh, well, Ms. Reyes, we'll take it into consideration. My ass.
At least he did that. I mean, instead of giving her a ruling on the whole thing, because the state attorney was saying, or whoever,
It's an assistant district attorney, yeah.
A prosecutor. He was saying that we're not supposed to even be arguing that
Yeah.
right now.
They wanted me to go over what my concerns were, blah, blah, blah.
On the subject matter jurisdiction.
Yeah, but I did complain about that. I was like, you don't have it.
But you
yes,
didn't,
we
you
did.
didn't, you didn't argue that thing in particular, get a ruling on that, and then move, and then that was it. Stop there, not even talk about merits.
Yeah, I know, but I have to learn this, and I know I'm going to make my damn mistakes.
Well, again,
But still,
where's the case law that says a complaint does not invest the court with jurisdiction of the cause?
exactly.
The fact that a complaint exists does not invest the court with jurisdiction of a cause, not even a
Exactly.
lower court.
And that's what I told him. I said, this complaint is not even factually valid. I said, you're missing all the elements. And, well, we need to go to trial, blah, blah, blah.
And he said that he was going to set an
Set me
announcement,
up for an announcement.
but he's still not ruled on your motion yet.
No, he has not.
I'm not really sure. You were supposed to have 2 motions before the
Yes.
court, but I never heard you talking about a second motion. I just heard you.
Well, everything in that motion goes over every freaking bit of that. So I got no response from the prosecution as to any rebuttal against that. So it stands as fact. That's
No,
it.
that's not how it works.
Well,
Okay, that's not how that works.
he's got to answer. So I need something in writing. And that's what I told him. I want something in writing.
Well, Eddie, the fact that she started arguing
Well,
the
let's
merits,
let Eddie watch it and then
I'm
he
just
can argue.
asking.
Yeah, you're just
Yeah.
telling, but don't tell him. Let him watch it.
Well, he
I-
might not have a chance to watch it.
Hey Eddie, I sent you that link
Yeah.
link and the video, but if
Yeah,
you don't,
I got the emails for it. I saw them, but I had other shit
I
on my plate at
understand.
the
well,
time.
I just want you to know, but that Dropbox, it has a time limit, and if you don't download
Okay.
it, you won't be able to get it. So it's
I'm sorry,
expiring
I
soon.
just saw it was a Dropbox, so I didn't.
Yeah, that's fine. But if you want the link, it's fine because that's on YouTube. But you can
YouTube.
download it if you like. It's up to you.
Yeah. If you have time, Eddie, look at it and then scrutinize me, please.
Okay, download files.
Just download it over the weekend and then scrutinize me when you have time, because I know in this class you've got other things you need to address.
Download
But
it
that's
now.
what they tell you.
Download it now. I mean,
But
No.
yeah, download it now before it expires
Yeah,
because it's
Download it now and then review it.
I'm
this
downloading it
Yeah,
now.
yeah.
Let me get it done here.
Yeah, that's great. Well, actually, you probably have it expires on the 7th, so you have time.
Yeah. And just take your time going through it and then scrutinize it.
I thought that's what I was doing, but obviously I'm taking too much time.
No, you're
This is-
fine.
This is Port
It's just a
Neches, right?
Dropbox thing.
You're doing too many
This
things
is for
at once.
Port Neches, right?
Yeah. Yes, and we're at county court at law too. So we'll go over that whenever you've had time to scrutinize it, and then you can scrutinize me next class as to what my next steps are and what I need to say, not say. And
well, one thing, she started arguing the merits, and so I'm asking you, Eddie, that's what I want to ask you. If she's arguing merits like half of the hearing,
so then I'm basically just
has
forfeiting
she
subject
waived
matter.
jurisdiction?
No, you cannot forfeit subject matter jurisdiction. You
Okay,
waived
that's-
personal jurisdiction the moment you did it,
Okay.
but subject matter jurisdiction is a matter of law, not acquiescence. They
Right.
either have it or they don't.
And they didn't. And we already addressed that. Hopefully the judge will have time to review the information that I submitted, but I don't know.
Well, she read the whole entire.
I did not read the whole entire thing, okay? Jane,
No, it's
don't
good.
don't
It's
exploit
good.
things.
I'm trying to tell you, it's good that you did that because it's on the record.
It
And
is on the record,
that's
but
what
at the
I'm
same
saying, but
time, I
you-
did not get the chance to read it, and I don't have time to read it. They just wanted to blow through it. I was there less than 30 minutes, and I was by myself the whole time.
Well, this is the part about why I pounded into you guys so much that you need to internalize your
I know.
information.
Yeah,
Yeah.
I hear
You've got to be able to talk about it in any angle and detail off the
Yes.
top of your head,
Yes, you're
including
right.
what law relates to it, why it relates to it, how it relates to it, et cetera, et cetera.
Yeah, I hear you, Eddie, and I know now what you're telling me. Everything that you've told us in class came to life in that moment. But I'm learning to stand up more and more. So each time I'm going to get better and better.
Well, that's unfortunately, that's the only way you're going to get better is by
Right.
getting your ass kicked more often than not.
Yes, you're right.
Okay.
And I appreciate getting my ass kicked, but not where it counts for me to get this shit dismissed so we can move on with the next steps.
They're gonna deny it.
We don't know that. So, well, more than likely they might. And you know what? I really feel like I should rebut. But
Well, again, did they give you anything to rebut?
No.
when you watch the video, Eddie, you'll see. Again, I feel like we're going to end up doing the same thing. And if we did a rebuttal motion, it would be the same way, just a little bit worded differently to get through to this young assistant district attorney's attention that there was no subject matter jurisdiction available. That was,
He said in there why they had subject matter. I don't remember what it was though.
no, they didn't.
Have you guys ever seen that football movie, The Replacements, with Gene Hackman
No.
and Keanu Reeves?
No, I haven't.
No.
Okay. Well, there's a scene in there where toward the end of the movie, they have a black receiver named Jones on the team who can run like the wind, but cannot catch to save his life. And
Okay.
he's their wide receiver.
Okay.
So during one of the last plays of the game, they put enough stickum on his hands that he looks like he's been, as he puts it in the movie, jacked off an elephant. Okay?
Yeah.
Just so when the ball gets to him, there is no way he can drop it.
Oh.
All right? The analogy here being that is how you should be with the facts and laws and procedures relating to your case. Nothing they do can get that information away from you and prevent you from hanging on to it and using it whenever and however needed. Okay?
Yeah.
But at the same time, it's also the way that a prosecuting attorney hangs on to his jurisdiction to prosecute. They will grasp at any straw and make any argument and say or do anything if they think it will let them continue with the case. You get me?
Yes. And now I understand that very clearly.
All right. So
I
what
saw-
he was doing was exactly the same thing.
Right. Right.
What? Who was doing? The judge?
The,
Who?
no, the
The
assistant
district attorney.
Well, the prosecutor
that is the assistant district attorney. Yes. He's the
whatever. He's still a prosecutor.
Yes.
Okay. Well, it doesn't matter. It's just senator. Doesn't even matter. He's still a prosecutor. Afterwards, he was asking her, "Will you please go over and identify or line out your specific points that you made?" But because she read the whole thing into the record,
But not the whole thing. Part of it. Yes.
most all of it,
Not
Ask her
most
to
of it.
read out the specific points from what?
from
The
her
complaint?
motion, from her motion to subject matter jurisdiction.
And what were the specific points you argued relating to subject matter jurisdiction?
That the complaint was not sufficient in order to prosecute.
Okay.
Went through those elements of the complaint were not sufficient.
All right. All right. So how exactly did you
I don't
word
recall.
that?
You'll have to go to the video.
All right. I'll look at the video.
I
The
prefer-
proper way to say it is the complaint fails to allege an offense.
Right.
It is
And
missing.
they said he said
it
it
is-
does.
It is missing specific elements of the alleged offense.
Yeah. But he was trying to restate the whole thing in the complaint. No, it has all the elements because it was at nighttime at 1,000 feet. It said,
I know, but y'all weren't supposed to be arguing the merits.
again,
I'm just telling you.
leave it where it is. The mistake was made.
I know.
Point is, they didn't have subject matter jurisdiction, and that's it.
All right. I'll try to get to watch the video sometime in the upcoming
And
week.
whenever you have time, just make some comments for me so I can go back and help
Well,
myself.
I'll make notes as I do it. I'm not going to do it without taking notes.
Yes, please, and let me know, and then let me know what my next steps that you feel I need to take are.
And you said it was about 30 minutes long?
Yes, sir.
Yeah.
It was. That's
Well-
about as long as I was in there, no more than that.
Well, you have the 28th of the month. They're going to do
Of July, yes.
July, but when they do an announcement for the
For
trial.
trial. But they still haven't ruled on it. But we'll see what happens because, you know.
Okay. All right. Well, in any case,
There's a bunch of people in here, Eddie.
did y'all see any flaws in the arguments made in the new motion to set aside?
No.
Not off the top of my head.
I'll do another review of the city attorney's response and see if there's anything that I missed. But all the stuff that was actually important, I think I addressed.
Yes.
But I'll review it again and make sure.
Yes. But what really would help me, Eddie, besides, the motions being as strong as they are, and I think it will help all of us as well, maybe practicing how to do a pretrial motion and, in vivo, or how to respond to things. I mean, besides knowing all the information verbatim, that's great. But when to actually, step in and say, oh, no, it's this, and it's this. You know what I mean? Do you get the gist of what I'm requesting?
Well, it depends on which portion of it you're talking about. It varies depending on what's being argued. As far as what's James arguing here about you arguing the merits, when you're arguing the insufficiency of the complaint and you're talking about the specific elements that the complaint allegedly doesn't contain, you're not arguing merits per se as whether or not you're guilty of anything relating to the merits. You're arguing that in order to allege this specific offense, these are the things the complaint must contain, and it doesn't.
Right.
So that's very different than arguing the merits, whether or not I am guilty of that specific point of the charge, et cetera, et cetera, et cetera. Okay? That's two different things.
Right.
So as long as she was addressing the insufficiency of the complaint, she was not arguing merit.
She was talking about headlights and lamps.
However, well, again, the complaint alleges two working headlamps, does it not?
Yes.
Yet that is not an element of the offense.
Yeah.
That's an element that they cooked up out of thin air.
Right.
So they're not alleging all of the required elements while substituting non-existent elements in place of them. That alone makes the complaint invalid. There is nowhere in the language of the statute that two headlamps is written. Nowhere.
And that's what I said in my thing, that there's nowhere in the language of that legislation. If it was going to be there, it would say must, shall, etc. But
it's not just about the must or shall. It's the fact that it uses the generic term lamp rather than the term headlamp.
Right. And
while every other part of that very same statute distinguishes between the two.
Right.
And that is the argument we made.
Yeah.
That a headlamp, the legislature specifically identifies headlamp where it means headlamp. And it uses the term lamp in general reference to the collective lamps upon the vehicle. And all it requires is that two lamps, one on either side of the vehicle, be lighted. That's it.
Eddie, can I ask a question?
Sure.
When they were writing the statute and they put that way, was that to give someone an out?
No,
because it would
the
seem
court is required to presume the legislature knew what it meant and intended to write and enact it as it did. They don't get to change the words.
Okay.
So the court must operate on the presumption that the legislature enacted what it intended to enact, regardless of what it says. And the only solution the court has to doing it that way is to say, Well, this may be what they intended, but what they intended is unconstitutional. Therefore, we rule that it's unconstitutional and unenforceable. That's the limit of their authority to deviate from what the legislature enacted. Otherwise, they must presume the legislature did exactly what it intended, and they wrote it exactly how they intended to write it. They don't get to substitute the word headlamp for lamp, because the legislature wrote the statute in a way that specifically proves they are two separate words and do not mean the same thing. Therefore, the court has no legitimate authority to make them interchangeable. Not as far as what the statute specifically requires.
Okay. Well, that's why I was wondering why the statute would do that, not knowing that it would be what you're talking about.
Well, that's just it. If they were following the language of the statute, it wouldn't be what I'm talking about. This is where the prosecution and the police officer don't read and understand the statute. So they charge an offense that the statute does not support. And then it becomes an issue for the court to decide whose interpretation is correct.
Okay.
But the court, in Helen's case, appears to not want to do that. They want it to be decided at trial, which
And they don't want to
is,
do that in anybody's case there, apparently, because they're making too much of a killing.
that's official misconduct on the part of the judge, because the judge is failing to use his judicial discretion to apply the law to the facts.
And this is usual.
This is quite normal, yes.
So they will, if we were to look forward, you pretty much have an idea because of your experience that they're going to have the trial. They're going to find her guilty, and then she's going to appeal, and then but she's going to have to pay some sort of bond.
Yes, double the bond.
And
Double the fine.
Yeah. So anyway, but that's the bond is doubling the fine, right? So,
yes.
So then she has to pay that in awaiting her trial. And so well, it's another court date, right?
Right.
Well, we don't know what date that will be until.
Okay, but then you go towards that. By that time, when you get your stuff from the court, then you file a motion to have it cast out for subject matter jurisdiction. You go along the same lines that you did. More than likely, the appeals court, are they going to just throw the case out and return her money?
Well, no, the appeals court is going to have to make a ruling and a written opinion on why she should have not been convicted or why she was legitimately convicted.
Okay. So her appeal makes it where she's not convicted.
No.
If
No,
she
well-
wins,
Well, if she wins, okay. Well, you made that statement. So anyway, okay. So she goes before the appeals court.
but that's the appeals court. This
Yeah.
is a do-over court.
Yeah, right.
This is just a lower statutory court.
I
So
know
this
that.
this court is conducting a whole new trial. But
Yeah.
our first issue is how this court gets jurisdiction from the lower court, because they don't have original jurisdiction in these cases.
So that's the first motion.
That's
Okay.
the first motion. The first motion here is the lower court never had jurisdiction because, one, there's no such offense in Texas law, and two, even if such an offense were legitimate, there are things missing from the complaint that must be stated in order to assert and prove the offense, and they're just not there. Thus, the complaint is invalid. Thus, the complaint cannot invest a court with jurisdiction to try the case. So they're still stuck on that same first square, no subject matter jurisdiction.
So when you say that the appeals court has to make a ruling, did the lower court have to make a ruling?
The lower court did what it always does. It assumes jurisdiction without any fact or
Okay, so-
evidence in support of it.
So it overlooked what she filed in her
No,
motion.
it ignored it. It didn't
Ignored it.
overlook
Okay,
it. It
that's what I
completely
meant.
ignored it, which is what they always do.
Right. So they ignore it. Can the appeal court do the same?
Sure, they can. And if she gets it overturned on appeal, I would argue that she needs to add the judges to the malicious prosecution suit, both at the original trial court level and the trial de novo level, because both of them did exactly the same thing, assume jurisdiction where it did not exist.
That's the lower
Therefore,
court.
they acted without any jurisdiction and have no judicial immunity for their acts.
Okay. So
And that's the part this city attorney in Jane's case doesn't seem to understand. Number one, she is not a county or district attorney. Therefore, she has no prosecutorial immunity.
she's a hired hand. She's a hired hand, just like the judge.
Exactly. So she cannot claim immunity from prosecution in a malicious prosecution suit because she's not a valid prosecutor.
Have you ever thought about taking this to the federal level? Just
This
in
is a
case?
state issue case. There is no federal. The only federal claim we can make is the denial of due process. But that
Right.
doesn't help us at the state level to fix the law and the behavior of our local courts.
Okay.
We've got to sue them at the state level and win, and then turn around and sue them at the federal level and win if we want to really put a bug in their craw that they got to fix what they're doing.
There'd be a lot less students in law school, wouldn't there, if you were to get these things passed into the state level?
Well, I don't know about being less students in law school, but there'd be less students in law school that graduate and attempt to do stupid shit once they have a job.
That's my point. I wasn't as quite descriptive as you.
But the fact of the matter is, when these attorneys are doing things the way these attorneys and these local judges are doing them, they are acting in a criminal capacity.
So now the appeals court will be elected. They're elected people, right?
I think so.
Okay. So okay. So is it
The
normal?
municipal court is the only one that's not elected.
Right.
Every other judge is elected to office.
Is it normal for these appeals courts to ignore what you say in your motion and just say, yeah, you was guilty, and so then she would have to take it into appeal another?
Well, and the only case that I've had to take to an appeals court, they overturned the conviction and ruled in my favor and sent it back to the lower court to refund my money and everything else, which they never ever did.
Oh gosh.
Okay. The county court at law number 8 under Judge Phillips in the decision on my case in Austin specifically said that he overturned the conviction. I've got the order still. I've got all the paperwork from them. He didn't want to rule on the motions that we filed. He didn't want to rule on anything about my case. He sat on it for over a year, despite the fact that they had a standing order from the Texas Supreme Court that they could not sit on a case for more than 60 days. They had to make a ruling in 60 days, and he sat on mine for over a year.
How do they get away with this?
Well, that was our question when we filed the final motion that got him to make a ruling.
I mean, can you file a civil suit against that court when
we
that
did
happens?
one better? We alluded to filing charges for due process violations and denial of access to the courts with the United States Attorney's Office.
Well, that's what I was talking
And
about.
the very next week, suddenly my motion had a ruling.
Well, that was what I was talking about. Federal level. You went to the federal level to get them to.
No, we didn't actually file it. We alluded to that we were about to.
Oh, okay. So then they knew. Okay.
And as soon as they realized that they had foobarred this beyond any ability to fix, they went ahead and ruled on my case and overturned it.
So basically, what they are thinking, all across the land in these lower courts, is that it's too much trouble for these people to fight it like you're fighting it. They'll pay this lower fine, this 250 or whatever it is. I don't know.
Yeah, most people settle because it's financially more convenient.
And so because they do so many and they know that, then that's the case.
Yeah, and that's why they don't care if one or two people out of 500 fight it, because their profit margins are too fucking big.
Eddie, you don't think that if you wrote and published a book with all of this, I know you got that look on your face. I mean, seriously.
What do you think the book I've been writing on is?
Well, but one that's actually, I don't want to insult you, but organized to the fact that someone can have a table of contents and then.
Julie, is the new one organized?
Oh, it's very organized.
I want to see it.
Well, it's not yet ready for public consumption.
Well,
okay?
That's why it needs to be. And I think then you gotta sell it. You gotta figure out how to sell this thing. And once you make it known, people are.
All I got to do to sell it is conduct a seminar on it.
Yeah. You think you could sell enough?
Oh, I'm willing to bet you I could sell enough.
Okay.
I could sell a lot of it.
Okay.
Now people aren't going to like the price tag because, like I said, this is damn near 2 decades of my life dedicated to what's going in this book.
Well, Dave Champion got his price.
Yeah, but his price was $100 for one book.
Yeah.
This is going to be 12 to 15 times that at a minimum, because it's not just a book. It's also legal pleadings. It's also everything, instructions on how to do everything, when to do everything, why you want to do it. It's basically law school in a book.
So basically you're saying Dave would probably purchase it.
He might. I don't know. Well, technically, I'd probably give Dave a copy of it for free, just so that when people from Texas call him about shit, he's got a reference for it. Because Dave and I kind of work cooperatively on individual clients between us. I'll get one that I'll refer to him. He'll get one. He'll refer to me, et cetera, et cetera.
Okay. So within the next year?
Again, stop trying to get a deadline out of me because I don't have one.
Okay.
I am busting my ass trying to get out of this dilapidated fucking shack before it falls in on my head. I've got my damn landlords cutting off my fucking utilities without telling me, trying to get me to move. I didn't know I was going to be able to do this class because the landlady's husband cut the internet off just before he sent me a text saying, "I've got an exit plan for you. Call me." And then I turned the text exchange of that conversation over to my attorney friend so he could look at it and see if his thinking on it was the same as my thinking on it. And it turns out it was. That the landlord is trying to make it appear that all the shit that's wrong with this house is somehow my fucking fault.
I gotcha.
Okay. So I've been a little busy, and it kind of stays that way because, like I say, I spend my entire daylight hours working with dogs. I don't have any choice. I got to make money somehow, and this is the only way I've got to do it at the moment.
So is your attorney, when you do you working with your attorney, he doesn't really have too many clients like you, right? That can point things out to him?
No, very few of them do, actually.
Yeah.
And
Well,
like I say, if you want a person who most likely knows the law the least, he's got a bar card.
yeah.
And that I saw firsthand
They know procedure.
twice already. Well, actually 3 times.
They don't even know procedure all that well.
No,
what they're doing with
they
the Code of Criminal Procedure is proof they don't know the procedure.
No, I've seen it 3 times now in all 3 of my issues already.
See, the only thing that an attorney is worried about is how they impress the judge. That's it. They don't give a shit about what the law says or anything else because the court doesn't. Unless one of the parties is being a real stickler with what the law says or doesn't say, the court could give a shit.
So that has to be me, the defendant, to throw it in their face.
Correct.
Like the biggest pile of horse crap.
And that's why it is so imperative for everyone that's going to do this to internalize the information you learn.
Eddie,
Yes.
when courts were put in place originally in the United States, it was to protect the rights of the individual.
Well,
right?
that's the excuse we're given for their existence. I'll agree with you on that point.
Well, but anyway, when they started practicing over the years, we have where we're at now, which shows that actually you, the citizen, have to know more than the courts and bring those things in the proper way and manner so that it's accepted in law and your case gets thrown out, and then they don't get held responsible as the officers of the court.
Correct. Let me see if I can summarize that for you a little better. While the concept of what a court is supposed to do that's portrayed to we the people is to protect our rights and give us a way to redress our grievances against our government, that's not what they are. They are there to create loopholes for their handlers to walk through. Basically, they decide how they want the law to work, regardless of what it says, and then they create opinions that do exactly that. Okay? An example being exactly like what is written as a rebuttal in James' motion here for the city attorney, arguing that the complaint is sufficient on its face because it complies with 45A.101. Well, the law does not require that certain elements be specifically stated in the complaint as part of the allegation for the charge. The actual statutory law doesn't require that. However, the case law does. Now, it's not always a bad thing when the case law does that. But what the case law should have done was said, look, because the statute does not do what it needs to do to actually provide notice of an offense, it should have been declared unconstitutional. But their every act is an effort to find a way to read the statute and interpret it so that they don't have to do that. Okay? And therein lies the rub. By trying to preserve the legislature's authority to make law, they actually violate the Constitution and the rights of the people to keep an invalid law in place by rendering opinions that provide additional elements that would save it if they were listed. One of those being, in the case of a speeding allegation, both the posted and the actual alleged speed. Okay? For instance, you can't say I'm speeding if you can't say how fast I was going. And you can't say that how fast I was going was actually speeding until you've got something to compare it against, which is the posted speed limit. So as you can see, those two elements had to exist and be alleged and argued and proven in order for a speeding offense to actually even be valid. Yet the statute doesn't say anything about those things. So the court saved an invalid statute by requiring through a ruling that these elements had to be written into the complaint in order for the allegation to stand. And that's the kind of bullshit they pull all the time. It's what they're trying to do in Helen's case with the headlights. They're trying to rewrite the language of the statute to require 2 working headlamps instead of just 2 working lamps on the front of the car. The problem there is the fact that the legislature did distinctly separate the usage of those two terms. One as being a general reference to any lamp on the vehicle, and the other being a specific reference to a specific type of lamp on the vehicle. And now the court has a quandary. How can we overlap them when the legislature, via the language of the statute, specifically separated them? Now the only thing they can do is either say, we're right, and there is no charge and no violation, or they have to find a way to rewrite the statute so that the state wins. So they're going to have to come up with an opinion that alleges something that the statute itself specifically says is not the case. Get me?
And then that next part, I think he wanted to argue was the failure to ID, which in the initial, when I first appeared, he's like, oh, well, we can drop the failure to ID and then just go off of, you could pay the fine of so much for the headlamp. I'm like, no deal.
And that's the other way they managed to keep you in the system and get away with, not having any of their acts questioned and their decisions overturned. Always cut a deal. Why do you think the conviction rate is 99.6% in the state of Texas? Because everybody takes the deal instead of fights the fight.
Right. Yeah.
That 0.04% of people is where we are.
When you're driving the interstate from city to city, they have these speed traps, and that's where they park and they wait for you to get there, and you don't see where the speed limit dropped down. And
yeah, but see, it doesn't matter. That's what I'm saying. In the state of Texas, that is an illegal stop, because the criteria for committing the offense is not simply going faster than the posted speed limit. The criteria is that you failed to control your vehicle due to the excess speed, and that failure resulted in a collision with another person or vehicle already lawfully upon or entering the highway.
That's the first time I've ever heard that.
No,
That's the criteria. That is exactly what's in the statute. And yet that is never part of the allegation. That is never part of the probable cause to initiate the stop and write the ticket. Every cop that pulls you over for going faster than the posted speed limit without witnessing a fucking collision or coming up on a collision that was admitted to by one of the parties has illegally seized you and your information and is illegally detaining you without probable cause. Because none of the requisite criteria for the offense have been met.
And that actually goes back to, thank you for saying that. That goes back to not having a verified emergency or injured party or property damage, correct?
Well, it doesn't necessarily have to be a verified emergency. The problem here is that the moment the lights come on, the cop is making a display of authority. That's what the lights are for. I'm a cop, either stop or get the fuck out of my way. He is displaying a legal authority that the police possess in the use of those lights. Now, if the use of those lights is intended to conduct a seizure of your person or property, then he damn well better have probable cause to do it. Not just a reasonable suspicion, but actual probable cause, a higher threshold. But in the case of a speeding allegation, the only thing that can give him probable cause is a collision. And then probable cause is retained only if the collision was a result of failure to control speed. If it's determined that the collision was caused by anything else, then probable cause evaporates. And he no longer has the authority to detain you or charge you because there was no offense committed as far as speeding is concerned. That's the issue.
How about those in-plate card license plate readers?
What about them?
What is your thought on that when there's absolutely no?
Well, if you're not required to have a license plate on your car, there's nothing for it to read, is there?
Yeah, I get that.
Okay. The issue here is, once again, what the law says versus how they enforce it. They enforce the license plate requirement upon cars that aren't required to have them.
No, I was talking about those surveillance systems that scan.
I know what you're talking about, but what I'm talking about is if your car was treated the way it's supposed to be treated and there was no plate on it, there would be nothing for that camera to read. Therefore, they could not be tracking everywhere your car has been through the data collected by that camera because there's nothing for it to read.
Well, they can now shut your car off, right?
Some cars, not all cars.
Yeah, because when they're doing that, that's a Fourth Amendment violation. That's an illegal search and seizure.
No, it's not. The license plate is in the public. If they can see it from the public, they have every right to take a picture of it, just like we do with our cameras looking at anything from the public.
I was thinking more along the lines of the fact that it's supposedly they're investigating if their system is out.
They're not investigating anything, and therein lies the problem. See, the argument is not that they took a picture of your license plate and invaded your privacy. The argument is that the computer automatically accessed data relating to your license plate that the officer has no legitimate authority to access unless he has cause to believe there's a crime afoot. The fact that the computer does the search instead of him does not negate that fact.
But again, as I asked that cop on the side of I told the cop on the side of the road, you don't have probable cause. He says, yes, I have probable cause. I said, no, you do not. I said, I would like to be seen by the magistrate immediately, and you are to do so.
And right now, you have a lawsuit against that cop for malicious prosecution,
Right.
or I'm sorry, false imprisonment.
Right.
That's a lawsuit that stands all by itself, no matter the outcome of the case. The problem is you've only got a year to make it.
Right.
I have the same situation as well.
When the cop fails to perform a duty required by law, he is no longer covered by qualified immunity. And the law specifically directs him to deliver a person directly to the nearest magistrate when he has arrested them with or without a warrant, because the warrant itself says to bring the person before the magistrate. Doesn't say to incarcerate them in jail, or at least it doesn't most of the time. Occasionally it will say, or to hold them in jail until such time as blah, blah, blah. But the problem there is that's still putting you in jail without a finding a probable cause to do so.
Mm-hmm.
That puts the judge on the hook in addition to the cop. All right, so what else y'all got? You got any more questions on that point, Tim? Or those points, I should say?
No, sir.
Does everybody understand what I'm talking about when I say these things? Because
Yes. It
to
makes
me,
a lot
this-
more sense when you go over it.
Valuable information, thank you. Especially the perspective, because you've got it.
What did Helen say?
That wasn't Helen.
No, not her. Helen. Helen said something, then this lady said something.
Yeah, I said that it makes perfect sense now that he goes over it.
Oh, okay. I thought you said something about over the speed limit. I'm sorry.
Well, again, it doesn't matter if you're traveling over the speed limit. That's the whole point. The speed limits in Texas are not fixed. They're whatever will allow you to travel without getting involved in a collision. If you're traveling at 90 miles an hour, but you're doing so in a manner that does not cause anybody else any problem or result in a collision, there's not a fucking thing they can do about it.
So Their argument, though, the law enforcement, is that they're preventing accidents.
Prove it. Until you have an accident, you can't prove an accident was ever going to occur. That is a completely subjective standard, which is on its face of the wrong standard. See, I don't think you should get paid money from your job. You should let me hang on to it for you because I subjectively believe that you're irresponsible with your money. Would you give in to that and say that, okay, no problem? Because
Nope.
that's what you're allowing the cops to do in such a case when they say, well, we're preventing accidents and deaths and all this. Bullshit. That's a theory you've got. That's your opinion, but you can't prove that you didn't prevent or that you prevented anything. There's no way that you can sit here and say, this is what we're doing. This is what you hope you're doing. This is what you subjectively might believe you're doing, but there's no evidence to support that this is what you are doing. However, what the evidence does show is you are enforcing the law in violation of how the law requires you to enforce it and what gives you probable cause to enforce it. That part we can absolutely show you're doing wrong. But what we cannot do is show that you're doing it right.
Hey, Eddie, here in California, it says requires drivers to never exceed a speed that is greater that is reasonable or prudent
Under the circumstances and conditions then existing.
Right.
Right. So, if under the current, whatever the circumstances and conditions then existing are, I have not lost control of my car, I have not collided with another person or vehicle already upon the highway, now is my speed unsafe and therefore not reasonable and prudent.
So it's better to argue that.
What is
instead
the
of LiDAR?
gauge? What is the gauge or the milestone for what constitutes reasonable and prudent? There must be a fixed goalpost. It can't be a moving subjective standard. It can't be 35 today and 40 tomorrow. What is the subjective or the objective criteria by which you can determine my speed was neither reasonable nor prudent? There's only one way. It can't be because you think so. It must be because something happened that caused injury to a person or property, thus proving my speed was not reasonable and prudent because it resulted in this injury. That's the only way they can do it. Anything else is 100% subjective bullshit. Make sense?
Totally.
Yes.
So the law is not based upon that's not how I would do it. That's not what I think it is. That's not how I want it to work. Laws aren't written that way. The laws are written to say, here is the criteria that says whether or not you're violating or not violating this particular law. And that's the criteria they're stuck with, whether they like it or not. The fact of the matter is they've gotten so used to doing it in a bullshit, lackadaisical manner that they can just allege something and everybody just goes, oh, well, crap, and accepts it, that they get away with it till it becomes a pattern and practice of normalcy for them. I'm not here to let them be normal. I'm here to kick normal in the fucking teeth. Because normal is wrong. And normal is illegal. And normal is unconstitutional.
Yeah, seems like most educations, public educations, are built towards relieving us of our rights. In other words, we don't have any clue that we have them.
Well, why do you think they stopped teaching civics in school?
Yeah, I know that used to be a common class. They just determined that.
And guess who was responsible for doing that?
Well, I was going to say someone like Karl Marx, but
No, Jimmy Carter's Department of Education. They're the ones that phased out civics. They didn't want the population to know and understand what the Constitution is, how their rights are protected by it, what to do when someone violates those rights. They didn't want us informed and educated on the subject.
is there anything that you can read, that's been published that shows that? Because you're saying it clearly.
No, I say it because in 1976, when which I believe is the year the Department of Education was created, I was in a civics class in my school. But by the time I was in high school, there were no more civics classes. By the time I was in the 11th and 12th grade, civics didn't exist anymore.
I don't ever remember. I'm a
Did
class
they
of
change it to, like-
77, and I don't ever remember a civics class.
Did they change it to like Texas government or something like that?
No,
Okay.
they replaced it with social studies
I see.
and started teaching foreign,
Right.
culture and habits and all this stuff, but
Yeah.
not ours.
Like world history and world geography and stuff. like that.
Exactly.
Well, here's the thing that I've also noticed in the years. Of course, Dave Champion has discussed this in many of his in his videos about, how the school shootings have increased over time. The other thing too is even in the schools now, the school districts are now paying up to $100,000 salary for each campus, at least in my district, and I know the surrounding districts are paying up to $100,000 for like sheriff's deputies and municipal police officers to now have at least one on each campus.
Right. And that's because now we've over medicated all of our kids and taught them that they can do no wrong and there are no rules.
Yeah.
We've turned out a bunch of spoiled, self-entitled brats that think that their feelings are the only thing in the world that matters.
And the thing is, I think we've discussed this as educators that too, this pipeline between the school and the jail is definitely evident.
Yeah. Well, we've got more private prisons than we've ever had on planet Earth before.
I mean, some of the markets that you can get your like mutual funds and things, some of those are privately invested in private prison systems and things.
All right. Any other questions, queries, complaints?
Just let me know whenever you're done viewing my information.
Hey Eddie, I had a quick question.
Go ahead.
I had an arraignment and they wanted me to sign the Faretta waiver. I crossed out a few stuff about waiving counsel that I didn't want to waive counsel, and the judge did not want to. She didn't want to take in the form. She wanted me to not cross anything out.
Well, too bad.
Signing everything, and they did in another arraignment. They pushed it back. This is the third arraignment actually, and they pushed it back. I don't know if I should file judicial misconduct on that.
Is she allowed to compel you to do that? Is she allowed to refuse to take your documents because of that?
I don't know. I guess I'll
To
find out
me,
the
if they're
next one.
saying that we will only take your paperwork if you waive your right to counsel, she's attempting to get you to waive a right that's protected.
Yeah, I specifically said I don't want to waive counsel in case I may need it, and I told her otherwise you're declining of my rights under Title 18, 242. And she said no.
Here's the problem, however. You either need to have counsel with you when you're acting as your own counsel, as second chair, or you're representing yourself. You can't bring an attorney in after the fact that everything has started. Okay.
Really?
Yeah. For instance, if you're at trial, you don't get to turn around and say, I brought an attorney with me today to act as second chair. Well, you've been doing everything up to this point by yourself. Okay. Not
On one
unless
of
you
the
put the
lines, it
court.
seems like under their discretion, they can allow it. I forgot. I think it was like letter.
They could allow it if you haven't, depending upon where we've gotten to. But the issue there is they don't want to have to allow it, and they don't want to have an appeal based upon ineffective counsel or lack of counsel for the appeal process. Okay, they want you to say, if you're going to do this, then you're going to do this, and you're going to tell us that you don't want counsel, so that we don't have an appealable error for there being no counsel. That's why they're doing it, is to cover all of their bases and yours. But the fact of the matter is, if you don't want to waive counsel, then you're obligated to at least be trying to locate counsel, even if it's in an advisory capacity. You can't just keep delaying your trial because you won't sign their paperwork. They can proceed based upon the fact that you refuse to acquire counsel. And they can make that determination after you failed to provide that paperwork X number of times. I don't know what X is, but they could certainly do it. Because imagine if somebody was charged with a mass murder of driving a vehicle into a crowd and killing 14 people, that they don't ever get to go to trial because they just won't sign the paperwork waiving counsel. You think the court's going to let that fly?
No, I understand that. I had a demur I wanted to file. Actually, I filed, which was filed in advance, and they saved me till the end. And they won't hear it out until I sign that. And public
Right,
defender,
because you filed a motion on your own behalf without
right,
assistance of counsel. So now they have to address it as if there's no counsel present. Or they want you to hire counsel who will then either argue it for you or withdraw it. That's what they want. So if you're going to argue your own motion, stands counsel, then you need to sign a waiver of counsel at the very least for that specific purpose.
right.
What you can do is instead of crossing out your form, it's simply write onto the form for the sole purpose of a motions hearing on such and such motion.
Yeah, and I plan on just reserving my rights under and signing it. I don't know if that'll help, but
Well, again, you're not losing any rights if you sign a waiver. But if you sign the waiver with conditions, then you're still not waiving your right to acquire counsel after the fact. Generally, that's what I would do because I want to see how they're going to act and respond to my demur. And I want to understand whether or not this court is actually going to comply with the law and uphold it. And if they're not, then I'm going to have an attorney to help me fight them the rest of the way. Hence, I wouldn't waive my right to counsel for everything. I would waive my right to counsel only for this proceeding and the hearing of this motion or this demur.
gotcha. So just you said write down for the purpose of this demur?
Only for the purpose of this proceeding and hearing of the demur.
Gotcha. Thanks, Eddie.
Mm-hmm. All right. Anything else before we get off here?
Are you gonna send me that?
I will send it to you as soon as I can get done here and get on the email. Yeah, Kevin.
What would be the probable cost for a registration stop?
What would be the cost for what?
What would be the probable cost?
The probable cause for what kind of stop?
A registration stop.
Registration?
The registration would be, or the fact that it isn't displaying one.
But that's
If the officer has reason to believe the car is one that's required to be registered. And guess what? If it's got license plate on it, that's reasonable suspicion that it's required to be registered.
okay.
Or presumed, right?
Well, that's what reasonable suspicion is a presumption. But it's based upon articulable facts. For instance, if you ask me as a cop, why did you stop that car for registration? Well, one, it's got license plates. Therefore, it's licensed by the state to operate commerce. Therefore, I have reason to believe that that car is required to be registered before they can use it upon the roads. See, articulable facts. Anything else?
Yes. Is there a separate motion to quash you've ever done, or is it relevant to do one for challenge in personal jurisdiction, in personam jurisdiction?
Well, a challenge to in personam jurisdiction is different than a motion to quash. A motion to quash is specific to the charging instrument. And it's either a motion to quash or a motion to set aside, depending upon what your state code requires. Here, it's actually a motion to set aside for a criminal complaint.
No, I'm here in Texas, Stephen, down in Hillsborough.
Okay. Yeah, here, if you're talking about the complaint or an indictment or an information, it's a motion to set aside, except for the indictment. The indictment is a motion to quash. Okay.
If they did make it to that step, which would be a miracle, it only would happen in the choice situation, then it would be a motion to set aside. Okay.
Yeah, the motion to set aside is based upon the fact that the complaint is invalid for some reason, or the charge itself is invalid for some reason, regardless of what the complaint says. So that's the distinction between the two. As far as challenging personal jurisdiction, that's a challenge to personal jurisdiction, and you've got to specify exactly why the court lacks personal jurisdiction, i.e., I'm a citizen of another state and do not live here. The alleged offense didn't occur within the territorial boundaries of the state of Texas, or something along those lines. Texas wouldn't have jurisdiction over an offense that wasn't committed in Texas. Texas wouldn't have a jurisdiction over a person that wasn't in Texas. You see what I'm saying? So the personal jurisdiction part doesn't apply. So why and how would you argue a lack of personal jurisdiction when it comes to whatever the thing is against you when you're within the state and it's a state allegation, right?
No, it's not. It's a municipal ordinance again, which only applies to the defined persons. But I thought that was the person that we were challenging. We're not one of the persons there. I apologize. I didn't understand that.
Well, again,
it was more of a territorial.
An ordinance is not a law, right? An ordinance is not a valid public law. It cannot be used against private persons and property for the purpose of prosecution of any kind, nor as a regulatory means, because municipalities are not authorized to create binding public law. Only the legislature can do that. Therefore, only a state law can be used to prosecute an individual. Now, that doesn't mean that a state law lacks personal jurisdiction. The Transportation Code is a perfect example. Every allegation in the Transportation Code lacks personal jurisdiction if you are not operating a motor vehicle in commerce. End of discussion. So not only do they lack personal jurisdiction because you are not a person who is legally considered a driver or operator of a motor vehicle, okay, but they lack subject matter jurisdiction because there is no evidence of transportation, i.e. commerce, upon which to hang their hat, and the regulatory authority of the Transportation Code. So that's your distinctions. Anything else? All right, then I reckon it's time for us to say good night. Folks, I want to thank all of y'all for coming. Glad you were here. Glad we got to talk about all this stuff, and hopefully you will find opportunity to join us again in the next session, or to actually subscribe to the class and continue to participate. In any case, welcome, thank you, and we will see you again in the future. Have a good night, everybody, and a good weekend.
Take care, you too.
All right, Eddie. Thanks, buddy.